what counsel harps on about he didn't write this, he didn't write that, where this seems to go is what he just said they didn't want to do. He's basically saying, we disagree with the evidence that's going to be presented in trial. And that, again, as he did correctly state, is something for different today. The phone call that he got that he wants to classify about someone to his significant other is kind of troubling because the person on the other line was the defendant's sister. So if he is claiming that's his significant other, that's just a whole other issue. They can claim that they interpret the call different. The call is what the call is. He claims he's got what he needs for his detox there at the jail. That's straightforward, and it is what it is, Judge. If they want to say it's something else, again, that might be a matter for a jury to determine what's on the call and what's not. But that's what the call says. That he didn't author the actual songs. Well, as we get to the trial evidence, that's not the law. The law is if you sing the song, it's an adoptive admission. You don't have to write them. But that beside it, when he starts saying, when you start looking at slime shit in anybody, I invite the court, look up on iTunes. It says, written by Jeffrey Lamar Williams. Okay? That's everything we see is there. If he wants to come in and say, I didn't write that, that's fine. It's in contradiction of what's out there and what is posted as being the truth. Those songs indicate that he wrote them. Now, that aside, it doesn't matter. If he sings them under all law, it's an adoptive admission. So, and the one who said Roscoe, he didn't give you the name on, respectfully I did, that's a Jimmy Winfrey, a member of YSL who's involved in these crimes. Every one of them here want to be a rapper. Right now, there's Mr. Kitchens, there's clearly Mr. Williams, and they're very successful at that. Other members of their gang are writing about the exploits of the gang, and Mr. Williams is singing about some of them. The fact that Mr. Williams didn't actually write that I didn't kill anybody, but I got something in that body, is still biographical. He's still in that role. That's still the truth, and we still intend to prove that, Judge. And again, it's an adopted admission. It doesn't take away anything that maybe he's not the one that penned the words. But again, as listed on iTunes and other such places, it says he wrote the songs. And maybe he's just doing that to get the credit, but he's going to come in and say, oh, that's really not true. Again, it's immaterial. Judge, what this is, and they're saying, okay, he was discharged because he went to pretrial intervention. I don't care. He's still in possession of a stolen gun, and it's still a trial fact for the judge to be able, for the court, the state to be able to prove that he's aware that he knew it was a stolen gun. And the reality of it is, they have so many stolen guns that we have the ability to show that always possessing these stolen guns, they knew or should have known that they were stolen when they get them and how they procure them. That's a trial presentation, and we're going to be ready for that when it comes, Judge. What they're basically saying is we disagree with the evidence, so because of that we say it's a material representation. It's not, Judge. Okay, at least I'll stand in my place as the prosecutor and say it's what we believe the evidence is going to show you. Now, I'm not clairvoyant. Mr. Adams and Steele may get to trial and they may be right. They may prove that I'm wrong. I may prove, and I intend to, that they're wrong. But that's a trial issue. What the statement said in the call, it says. What this evidence says, respectfully, it says. If those songs are adopted admissions, he sings them. And even one case goes so far as to say, even if another member sings it, it's an adopted admission if you're in there. The same thing with if you're in the song singing about your gang and all your gang members are in there, it's an adopted admission by them as well, even though they're not singing and they didn't write. Judge, I would say that they ignored the law when they argued the points. Your Honor, they argued to the acts of 16, 17, 18, 19, which is the murder of Gunna and Thomas. They want to say that there's no credible evidence and therefore it's prosecutorial misrepresentation. I'd ask the court to wait for trial because I was reading the fact that there's going to be no evidence on it. I'll just put it that way, Judge. Sacrifices that must be made. Your Honor, to my knowledge, those are the words of Mr. Williams. In that string, and it's a group chat. To my understanding, I'm wrong twice today on the Judge, I could be wrong again, but to my understanding and knowledge, those words are Mr. Williams. So I think what we have here is they've gone through the indictment and they want to reclassify or put defense spin on the evidence in the indictment to say that I'm materially wrong. I still stand behind the representations I made, Judge. And I believe this is going to be the third, if I'm not mistaken, time they've asked for bond. They denied bond on 5/11/22, 6/2/22, and I don't know what the court's going to do today. But on 6/2/22, the court denied it on all four bases. And Judge, we stand behind the representations we made. To my understanding and belief right now, they were all correct. They might have a different spin on them. They might be telling or forecasting what their trial strategy is to fight the evidence. But again, that's a trial strategy. And I can tell the court, I'm sitting here looking right now at one of the ones for slime shit. It says written by Jeffrey Lamar Williams and Ricky Harrell, Harrell. That's wrong. That's what he's putting out. If he wants to change it, there's nothing I can do about that. Judge, we'll deal with it when we get there. Your Honor, he runs, and I mean he runs, he's the general. He says in the song, he's the general. He runs a very violent street gang that has committed numerous murders. Respectfully, Judge, if he's let out with the number of people that are still out there in YSL, I would expect that to continue, and I would expect witnesses to be in danger. Again, I have nothing specific that Mr. Williams has made a direct threat. This is the gang, members of the gang, relations of gang members here that are in jail on this case have made them. One of them is actually in jail for that threat. And I don't know the way to put it, I don't mean to insult the court, but this is the real deal, Judge. These are very violent people, they're very dangerous people, and I believe the finding on June 2nd is correct. We'll flesh this out at trial, but all four of those factors still apply. There has been no material change. There has been no misrepresentation. There's a disagreement with what the evidence at trial is going to show, and I believe then that means they do not counter the order that the court signed on June 2nd. They do not carry their weight on the ILL factors, and I ask the court to deny bond again.